This claim invokes the original jurisdiction of the court and concerns not only an interpretation of a revised Treaty of Chaguaramas to ascertain the nature and scope of the duty of contracting states to charge and collect the Common External Tariff on the importation of brown sugar, but also the burden and standard of proof that must be met by a contracting state to prove breach of the treaty obligation, as well as the nature and extent of the relief, if any, which may be granted by the court if satisfied of a breach. It is clear that the burden of proof rests upon Belize and that the claim must be proven to the satisfaction of the court. The court has recognized that breach of treaty obligations can be proven by way of circumstantial evidence. It has held that such evidence is admissible and may be relied upon where two conditions are satisfied. One, the direct evidence is under the exclusive control of the opposing party. And two, the indirect evidence does not contradict any available direct evidence or accepted facts. The claimant has relied on documentary evidence to prove the breach of Articles 82 and 83 of the Revised Treaty of Chaguaramas. It is conceded that documentary evidence before the court is not of itself of sufficient probative value to make out the case. We accept that the quality of evidence presented by the documentation before cannot on its own make out the case. Belize sought but failed to secure disclosure of documents in the possession of Trinidad and Tobago, which would have constituted direct evidence of the importations alleged to have been made in breach of the treaty obligations. Belize says that the application itself demonstrates that any direct evidence of the importations is indeed under the exclusive control of the first defendant in this case. Belize further says that the inference it asks the court to draw from the circumstantial evidence presented does not contradict any available direct evidence or accepted facts.